A first for a sitting president. Trump attending today's Supreme Court hearing as he works to restrict the 14th Amendment right to birthright citizenship. The case stems from a challenge to the president's executive order signed in January of last year, restricting the right of people born in the U.S. to be U.S. citizens. It's since been blocked by lower courts. Trump's appearance today, while unprecedented, did not last long. The president left after about 90 minutes during plaintiff arguments. Joining us to discuss all of this is legal expert Erin Carr, assistant professor of law at Seattle University. And Erin, thank you so much for being with me.
Hi, good evening.
So we want to start with this question. How significant is this case in terms of constitutional law and immigration policy in the U.S.?
Well, the fact that the president, for the first time in American history, attended today's Supreme Court oral arguments, I think speaks to the importance and historical significance of the issues before the court. This case could potentially redefine a key provision of the Constitution and could fundamentally change what it means to be an American.
And Erin, I know both sides argued for more than 2 hours today, trying to understand more about what Trump is trying to do here. So how does the Trump administration justify excluding children of undocumented immigrants or temporary visa holders from citizenship when it is so clearly stated in the Constitution?
Well, it's been long established that the Constitution's birthright citizenship provision entitles every person in the United States to citizenship, with very few exceptions. Dating all the way back to the 1890s, the Supreme Court has consistently held that the plain meaning of the 14th Amendment's birthright citizenship clause, in combination with American and common law history, all support a broad interpretation of birthright citizenship protections that entitle children born on American soil to U.S. citizenship, irrespective of their parents' status. Congress has also endorsed this interpretation when it passed the Immigration and Nationality Act of the 1950s, codifying birthright citizenship into federal law. However, during President Trump's first term in office, a novel theory emerged that has since been used to justify the president's birthright citizenship policy. And this particular legal theory advances a highly technical and much more limited interpretation that primarily focuses on just 5 words in the 14th Amendment. The phrase, "subject to the jurisdiction thereof." And the administration has selectively relied on conflicting historical sources to argue that this particular phrase operates as a constraint on birthright citizenship, which allows them to deny citizenship to children born in the United States, to undocumented immigrants, as well as to lawful permanent residents. And under this novel constitutional interpretation, the administration has argued that a person must be domiciled in and have allegiance to the United States in order for their American-born children to be eligible for American citizenship. And yet a majority of justices today seemed rather skeptical of that argument and also had questions about how precisely that legal standard would be determined, let alone administered by the government.
And Erin, the skepticism, is there a chance they could rule in his favor? And roughly how many people would be affected by this if it was to be repealed?
Well, a Supreme Court ruling limiting constitutional and statutory protections for birthright citizenship would result in millions of Americans no longer meeting the criteria for citizenship and could lead to the creation of a permanent class of stateless, disenfranchised, and legally vulnerable people with no nationality or citizenship. If allowed to go into effect, the administration's birthright citizenship policy would deny citizenship to an estimated 200,000 babies born each year in the United States, which would result in over 6 million people being denied legal status by 2050. And the impact of this policy wouldn't only be limited to undocumented immigrants, but would also affect and disproportionately harm Asian and Latino families who are in the country lawfully with various forms of temporary legal status.
And Erin, I want to also mention that maybe people are wondering, why are we not seeing images of Trump from inside today? That's because video is not allowed, but those oral arguments were heard. So what do you make of his presence, and how might it affect the court's decision?
Well, President Trump has been pretty brazen in bullying and intimidating members of the court, particularly those justices who he appointed and who he seems to believe owe him a personal debt that entitles him to favorable judicial rulings. And so, to the extent that the president's attendance at today's oral arguments is a continuation of that intimidation campaign and was intended to pressure the justices to produce a favorable decision on his behalf, it doesn't seem like it was very effective. All indications are that a majority of the justices were unpersuaded by the administration's arguments and are not inclined to allow the president to unilaterally rewrite one of the most consequential constitutional provisions.
Erin Carr with Seattle University, thank you for your insight and context as we are seeing this play out at the Supreme Court. Of course, we'll keep you all updated once we learn anything new, but it could be quite some time before we learn a decision. Erin, thank you.